Hello, my name is Elena Pop, and I'm the Executive Director of the Eviction Defense Network, also known as EDN or EDEN. This video is intended to be used with our webinars and our empowerment classes. This video does not replace legal advice or an assessment of your case by a lawyer, but it will make you a badass eviction litigant. Please remember that laws change and the most up-to-date information is on our edn.la website and at our Zoom events.
Hello, my name is Mark. I'm a successful participant and student in the EDN Tenant Empowerment Program. The Eviction Defense Network is a proud member of the LA County Right to Counsel Coalition and its Stay Housed LA program.
If you have a disability, including a learning disability, and need a reasonable accommodation, please let us know.
We cannot have social justice without language justice. Please help us by being patient with the interpretation. Unless we are interpreting simultaneously, speak one sentence at a time. Wait for the interpretation.
We know you're stressed. Overcome your stress through knowledge and power. Watch the videos, come to the webinars to learn the law. Come to the empowerment classes to learn the procedure and how to be a winner. Come to the tenant support group to get love and understanding and to be around people that have gone through what you are going through and were victorious.
We have developed a video series that gives you all the information you need. The videos are divided into 3 categories. 1, how to get legal help. 2, mastering the eviction process. And 3, knowing the law.
You are here. What to expect my first day in court.
Please watch the videos in order.
These 3 give you the fundamentals that you need to understand the webinars and classes.
Watch our From Zoom to Victory video to learn how to be a powerful participant in our Tenant Empowerment Program classes. If you can't name yourself correctly or write a good PIP, we will ask you to watch From Zoom to Victory in a breakout room and to work with a volunteer. This will delay your participation in the empowerment class and counseling. By the way, if you don't know what a PIP is, you haven't seen From Zoom to Victory. Please watch it.
We are here in the eviction process.
The key to success is preparation. Remember that journal? Be diligent. If someone says something that doesn't sound right to you, like, if you eat green eggs and ham, you will win.
Come check it out with us at an empowerment class.
Don't misuse the cell phone, or it will not be available to you for your court appearances.
If you have followed our instructions, you are well versed on settlement possibilities.
You are familiar with the 16 factors to consider and how they apply to your case.
You know the negotiation process.
That you need to learn to play poker, chicken, and let's make a deal to be a good negotiator.
You have gone to your courtroom and watched at least one session. If your court date is at 8:30 a.m., go at 8:30 a.m. If it's at 1:30, go at 1:30. Sit and watch. If you're asked why you are there, say, I am an EDEN Tenant Empowerment Program student, and one of my assignments is to spend at least one court session getting familiar with my courtroom and my bench officer. Thank you for asking.
By now you have an exhibit notebook.
And a trial notebook.
If you have a place to go and you want to move with the forgiveness of rent, a clean record, and maybe some relocation money, you have filled out this stipulation for judgment form. You have 4 copies in the front pocket of your exhibit notebook. 1 copy has your ideal offer. 3 have the move-out dates and the relocation money blank to give room for negotiation.
If you want to stay with a payment plan, you have filled out this settlement agreement form. You have 4 copies in the front pocket of your exhibit notebook. 1 copy has your ideal offer. 3 have the details blank to give room for negotiation.
The notice of trial.
You found out about your first court appearance when you got your notice of unlawful detainer trial in the mail. Tenants often don't get this notice. This is why you need informed delivery at the U.S. Postal Service. If the court sends you something and it doesn't arrive, you can investigate. You should also be calling the court every 10 days to see if a trial has been scheduled.
All the notices of unlawful detainer trial say non-jury trial, even if you properly demanded a jury. This is because the court's very expensive computer system does not have a way to say jury trial in an eviction case. Regardless of what this notice says, you will get your jury trial if you asked for it and filed an FW 002 for jury fees or paid $150 on time. Now is the time to verify.
The deadline for asking for a jury trial is 10 days from the date of mailing of this notice.
To verify that you made a demand, look at page 5, paragraph 5 of your answer to make sure the demand is there.
Or verify that you made a separate demand that was actually filed on a form that looks like this.
The deadline for filing the FW 002 for jury fees or paying $150 jury fee deposit is 5 days before the trial date.
The FW 001 is the initial fee waiver application. The eligibility chart is at the bottom and shows if you are eligible or not.
The FW 002 is for jury fees, interpreter fees, police officer fees, etc.
The FW 003 is the order. Go to the court and get a copy of the Registry of Actions. Verify that you have, number 1, a jury demand, number 2, an FW 001 and an FW 002, number 3, an FW 003 approving your filing fees for the answer, and number 4, an FW 003 approving your jury fees. If anything is missing, file it again.
If you preserved a jury, in your PIP, say jury preserved. When you sign in at a webinar and tell us you have an appearance date, say your first name, 223, jury trial, first appearance. And if we ask you at an empowerment class if you preserved a jury, say yes, and I have verified. Don't say yes, but my notice of trial says non-jury. All the notices of trial say non-jury. If you have not preserved a jury, do it now. If it's past the deadlines, file the jury demand and the FW 002 or pay the $150 and ask us at an empowerment class about moving to be relieved from jury waiver.
Why does it say possession is no longer at issue? It doesn't. The box isn't checked. If a tenant moves out during an eviction, the case loses priority. It becomes a regular civil case. The box is there so that the judge knows not to set a speedy trial if the tenant has moved. But you should not move without making every possible effort to get rid of the rent debt. Being in possession of the unit is leverage for getting rid of that rent debt, for getting it forgiven. Don't move out before you've made a deal. If a tenant moves, most owners just give up on the rent, knowing that the tenant does not really have the money and collecting will be very difficult. Usually the owner just dismisses the case and forgets about it. But because post-pandemic, the amounts of rent owed are so large, more and more owners are wanting to go after the tenant for the rent debt. If the tenant moves out without resolving the rent issue, the trial is rescheduled for months, if not years from now, and you don't really want that. Resolve the issue now before moving out.
So what will happen my first day in court?
First, get up early, have a nice breakfast, and get dressed. Appearance is important. Dress for victory. Be neat. Business casual. Not very dressy. Don't be the guy that came to court in a designer suit with a designer briefcase and designer shoes to talk about how he had been affected by COVID and can't pay the rent. Even though those designer items were probably bought pre-pandemic, the optics were not good. Don't go to court in a cocktail dress. Dress for Easter Sunday or in hip huggers, shorts, short shorts, showing too much cleavage, or in a white muscle shirt with baggy pants showing your boxers. No jeans, no sweats, no t-shirts.
At 8 a.m., you will text your PIP to the 2 cell numbers we gave you at the empowerment class. One message to both numbers to create one text string with you and 2 EDN staff members. Your PIP must always be up to date. To make it up to date, delete anything that is no longer relevant and add a sentence about why you are texting. Example, I am in court department 91 this morning at 8:30 a.m. I preserved a jury. This is my first appearance. There are 450 TEP students and hundreds of retained clients. The words remember should never come out of your mouths. We don't remember. We keep records. We have files. And you have to remind us by sending us an up-to-date PIP every time we communicate. Review your PIP each time before you send it and delete old information. Add new relevant information.
Arrive in court 45 minutes early with your 2 notebooks. Consider these notebooks your originals. You do not need copies for the other side on your first trial date. If the other side asks you for a notebook, show it to them, but get it back. You have not made copies. It's a work in progress.
If you have a place to go and you want to move with forgiveness of rent, a clean record, and maybe some relocation money, you have filled out this stipulation for judgment form. You have 4 copies in the front pocket of your exhibit notebook. 1 copy has your ideal offer. 3 have the move-out dates and the relocation money blank to give room for negotiation. If you are seeking relocation funds, we have discussed what a reasonable amount of relocation might be based on your 16 factors.
So you'll note that we are repeating ourselves a little bit on these slides. It's because teachers are taught to tell them what you're going to tell them what you told them. It is our hope that if you hear it 3 times, it'll actually sink in. So if we're being repetitive, please forgive us. It's so that to emphasize the important points of what you need to do. If you want to stay with a payment plan, you have filled out this settlement agreement form. You have 4 copies in the front pocket of your exhibit notebook. 1 copy has your ideal offer. 3 have the details blank to give room for negotiation.
If you have all or most of the rent and you want to stay, bring it to court in certified funds, a cashier's check. Make the landlord weigh the cost of multiple appearances to be assigned a judge and 5 days of a jury trial against the money you have in your hand.
When you arrive at court, go to your courtroom and look at the roster called the docket that is posted outside the door. The cases are in case number order. Because the file is sealed, your name does not appear on the docket. Only the owner's name appears. Find your case number and make a note of your 2-digit docket number. If you preserved a jury and it says non-jury trial, don't panic. Remember the issues with the computer system.
The door will be closed because you are there early. At some point, the bailiff will come out and ask for people to step forward to check in. Get in line, and when it's your turn, check in with the bailiff by giving them your 2-digit docket number and saying your name. In some courts, the bailiff announces all parties check in with the clerk. In that case, you will go inside to check in with the judicial assistant, more commonly referred to as the clerk.
If your bench officer is a commissioner rather than a judge, the bailiff will ask you if you stipulate to the commissioner. In the courts in which Eden practices, we have 4 commissioners, We recommend you sign the stipulation to the commissioner to keep Boxer in Department 97 downtown and Gridiron Winston in West Covina. We recommend you refuse to stipulate to Dodson in Pasadena and Acevedo in Compton. We could not find an image of Commissioner Dobson online, but we did find his special rules. They basically say, I expect you to follow the rules. And so we're going to go over these rules later. Your bench officer, if your bench officer is not there, text us the name of the bench officer that is covering. At this point in the presentation, Caro, who is another leader in the empowerment program, is going to take over because our attorney time is super unpredictable. I had all morning when the day started yesterday to do these recordings, but a case from the empowerment class went to trial and I stepped in. So I've got to run downstairs to do that trial. Thank you for being with us and please stay tuned as Caro takes over my role.
As stated above, you have a right to a judge. If you are going to give up that right, they need your signature. Sign the stipulation for Boxer at 97 and Gridiron Winston in West Covina. Refuse to sign it for Dodson in Pasadena and Acevedo in Compton. If you refuse to sign, you will be assigned a judge. You may have to come back to this court a few times before that actually happens.
Hello, I'm Caro, proud attendant from our class. If you have an offer to make, you want to approach the plaintiff's counsel rather than wait for the plaintiff's counsel to approach you. You can move away from the bailiff and call out to make the firm. Example, counsel from KTS. Example, counsel from Black firm. Or you can wait until the bailiff is done with the check-ins and ask the bailiff to identify the opposing counsel on your case.
We have already established that you are not going to be late, but just in case, the bailiff sits here. If you need the bailiff's attention, signal to them from the audience side of the bar. Do not cross the bar without permission.
If you want to move out, have found a place and are ready to make an offer, find and approach opposing counsel. You should introduce yourself like this. My name is, say your name. I am case number, say your case number. I am docket number, say your docket number. In department, say the department number. I am interested in exploring a move-out agreement. I need, you give the number of months, a forgiveness of all rent, a sealed record, and you give the amount of money that you want. The amount of money we decide is reasonable in your case. If we reach an agreement, I expect to use this form. The amount of time you ask for and the amount of money you should have been determined at the empowerment class, and you should also have determined how much more you need to ask to get to your actual goals. We also identified your bottom lines.
Give the lawyer the copy with your ideal offer. Bargaining will start. Your response to the bargaining should be, today, that is my first, last, and final offer. If you are not prepared to accept that offer, we should request a mandatory settlement conference. A mandatory settlement conference is a negotiation session with a mediator. 2, if you are willing to bargain a little, your response should be, give me your best offer. We are too far apart. We should request a mandatory settlement conference. If we developed a speech for you at the empowerment class, use that speech.
If you want to stay and are ready to make an offer with a payment plan, say, My name is, say your name. I am case number, say your case number. I am docket number, say the docket number. Department, say the department number. I am interested in exploring a pay and stay agreement using this form.
Give the lawyer the copy with your ideal offer. Bargaining will start. Your response to the bargaining should be, today, this is my last and final offer. If you are not prepared to accept that offer, we should request a mandatory settlement conference. If you are willing to bargain a little, your response should be, give me your best offer. We are too far apart. We should request a mandatory settlement conference. If we developed a speech for you at the empowerment class, use that speech.
If you are not ready to make an offer, say, my name is, say your name. I'm a case number, say your case number. I am docket number, say your docket number and department number. I will be waiting for you inside the courtroom. Wait for them to initiate the dialogue and use the speech we developed at the empowerment class.
Find the EDN attorney and introduce yourself. Annika Vale-Cole and Elena Pop are our main court attorneys. Vivian Zambrano and Simon Sherrod cover court when needed. Introduce yourself with, my name is, say your name. I'm a TEP student. My case number is, say your case number. I'm docket number, say your docket number. And I'm in court department, say your court department number. I've made my initial offer to opposing counsel. I'm very excited about using the skills I've been learning at the empowerment classes, but wanted to introduce myself in case I need help.
The key to success at this first appearance is to be clear about what path you are on and to be clear about your ideal offer and your bottom line. If you preserved a jury, do not feel pressured into accepting any offers. Stick to your ideal terms. If you did not preserve a jury, there is a risk that if you don't settle the case, the judge will be available to do that trial that day. At the empowerment class, we should have identified the risk and made a plan for it.
Be ready for opposing counsel's response. They are usually very nice at first. They will offer to forgive the rent if you move in a short time. They will make it sound like this is the best thing for you. They will act like they are your long-lost best friend. They start off by saying things like, let me see what I can do for you. I really want to help you out. I want to make sure you don't get saddled with a huge debt and have plenty of time to move out. I'm here to see if I can help you out with this case. The judge wants me to have a chat with you to see if we can negotiate this. If you go to trial, the odds are that you are going to lose. I am here to help you. I want to do what is best for you.
If you don't accept this, their offer to move out, they will get more and more gruff and threatening, saying things like, I am doing the best I can by you and you are going to lose. Or, I do understand that your rent is not due, but again, the judge really wants me to spend time negotiating with you. And if we don't get this case settled and it goes to trial, he's going to be upset that you did not negotiate with me. Or are you prepared to lose this case and have an eviction on your record and prepared that you won't be able to get another place to live? Or it's in your best interest to negotiate so we can get this settled. We can keep this off your record, and or you can risk never being able to rent again. Or Are you prepared to lose your case? You seem very confident. I am really here to help you. It's not losing good for you. Or are you willing to risk to not ever be able to rent again? Risk it all, risk your home, and have your future affected? Are all of these are actual quotes brought to us by other TEP students. Take notes of what they tell you and bring it back to an empowerment class so that we can add to our repertory. The landlord's attorney is not your friend. They are trying to con you into taking a deal you don't want.
Eventually, they will try to bully you into accepting a deal.
If you don't settle this, will go on your record. You will never be able to rent again. You will have a judgment against you. It will ruin your credit. You will owe all the rent you have not paid. The sheriff will come and drag you out without warning. You are going to respond in your very best late night FM DJ voice. Let's go talk to the judge and ask for a mandatory settlement conference. At a mandatory settlement conference is a supervised negotiation with a mediator.
We have even heard that one landlord lawyer gets frustrated and says, "You have been talking to Elena Pop. You have drank the Kool-Aid. She doesn't know what she is doing, and you will end up with an eviction on your record." False. While there are no guarantees, we have a higher than 99% success rate for tenants that have followed our instructions in the empowerment classes. Most of you are still in the process. Based on what you tell us about your information at the empowerment class, we will help you draft a response to these threats, and we will practice saying it from a place of power. Your response at the end will be, "Let's go inside and ask for a mandatory settlement conference." Your goal at this appearance is to get a mandatory settlement conference.
Don't get dragged into the drama. Give your speech or say, "Let's go inside and ask the bench officer for a mandatory settlement conference."
Don't defend EDN or Elena Pop. Don't get sucked into that conversation.
Stick to your speech. In other words, let's go inside and ask the bench officer for a mandatory settlement conference. De-escalate by using your late night FM DJ voice.
And to be clear, you are all superheroes, but this is not appropriate court attire.
If you are asked, "Is Elena Pop representing you?" or "Is EDN representing you?" the answer is, unfortunately, not at this time. I am a tenant empowerment program student. I hope that timing will work out for them to represent me, but at this moment, I do not have an attorney.
If you don't have a place to go and you preserved a jury, it's too early to make a move-out offer. If you did not preserve a jury and you have been following instructions, we have a plan for today that we have made at the last empowerment class.
If you are able to make an agreement, it is safest to get the new dates and allow us to review it. If you have simply filled in blanks, we may be able to review it via text. If an EDN lawyer is in court, have them review it. Do not go off script. You are filling in blanks in the form. You are not using the form. You are not editing our form. Do not feel pressure to make a deal at your first appearance.
If you don't come to an agreement, new dates will be set.
This is a diagram of most courtrooms. In Department 6691 are in Pasadena and the 2 in West Covina. The jury box is on the left and defense counsel table. The clerk and bailiff are all on the right. The plaintiff always sits closest to the jury box. If you have drawing skills, make a diagram of your courtroom. Do not take picture inside the court building. Do not cross the bar unless you are invited by the judge or bailiff or clerk. The bar is the barrier between the audience and the counsel table.
When the case is called, cross the bar and sit on the defense side of counsel table. Again, it's the side farthest from the jury box. It will say defendant on the table. Let the judge and plaintiff's counsel take the lead. If a deal was reached, the judge will review and sign off. If no deal was reached, plaintiff counsel will report that. Suggest a mandatory settlement conference to the judge. When the judge gives you new dates, make sure you know whether the next date is mandatory settlement conference, trial setting conference, or final status conference with a trial date. Write down the dates and times. Clarify what type of appearance it is. Be poised and confident, not cocky. Thank the bench officer. Thank you, Your Honor.
The actual appearance in front of the judge should go as easy as that. But if you don't reach an agreement, the judge may put some pressure on you. Sometimes they say things that could look like opposing counsel. The only way to control the outcome is to make a deal. You never know what's going to happen in a trial. If you lose, there will be an eviction on your record for 10 years, making it hard for you to rent. Jury trials are very hard. Are you sure you don't want a bench trial? This is a good offer and it may not be there when you come back. I am just going to make one change here because you don't need it.
Thank you, Your Honor. I'm sure I want my day in court. Thank you, Your Honor. I'm aware of the possible negative consequences, and I'm sure about my settlement position. If plaintiff can't agree, I'm sure I want my day in court. Thank you, Your Honor. I am a proud participant and student in the EDN Tenement Empowerment Program, and I am confident I will be ready for each appearance. Stay firm. Do not be intimidated by the judge. Recently, a student who was very firm just seconds before said that she was not going to sign the proposed deal on her first appearance, but then gave in under pressure from the judge. There was no reason to feel pressured. You can inoculate yourself against the pressure that comes from the judge by going and watching the court several times before your trial.
If the judge says, I am just going to make one change here because you don't need it, say, please don't, Your Honor.
Recently, a judge made a change to a stipulation stating that the student did not need to come back to court to set aside and dismiss the case. You do need this. The commissioner, in this case, is both new and wrong. The student gave in. I'm going to make a small change here because you don't need this. Your Honor, please don't make any changes. That is the agreement that we negotiated, and every word is there for a reason. I am in the EDN Tenant Empowerment Program. If you feel a change is needed, please return the form to me so that I can have your proposed change reviewed at my next tenant empowerment class. Or give me a chance to text the instructor that is helping me this morning. If one of us is in court, say you want time to talk to us. If the judge says no, then say, I'm sorry, Your Honor, but then there is no deal. Can we have a mandatory settlement conference date? You can inoculate yourself against the pressure that comes from the judge by going and watching the court several times before your first appearance. Don't be intimidated, even if the judge starts to get angry. The angrier they get, the calmer you get. The louder they get, the deeper your late night FM DJ voice gets. Again, you can inoculate yourself against the pressure that comes from the judge by watching the court several times before your trial.
The bar, the well, the bench. The more familiar you are with the courtroom, the more comfortable you will be on the date of your court appearance. Make time to go and sit in your courtroom. You can do that in all courts except Pasadena. If you're asked why you are there, say, I am an EDN Tenant Empowerment Program student, and one of our assignments is to get familiar with our courtroom and our bench officer before our first day of trial. I am here to watch. Thank you. Be super nice to the bailiff and the clerk. If your case is in Pasadena, go to another court. The commissioner in Pasadena only takes that bench when he has to add. They keep the court empty, so you will be mainly outside even on the day of your appearance. We could use help developing actual diagram of each of our courtroom. If you have the skill set, please do it and bring your diagram to an empowerment class.
This is a typical courtroom, but sometimes the jury box is on the left. And if that is the case, the clerk and the bailiff will be on the right, and the position of plaintiff and defense tables will also switch.
Note that the court there is only one witness stand. It will be closest to the jury box.
The judge sits on the bench. You can't go near the bench without permission.
This is the witness stand. Only approach it when asked by the judge.
This is the edge of the jury box. The jury is 12 members of the public, your peers, plus 1 or 2 alternates. They are chosen from 35 to 45 members of the public.
This is the bar. To be a lawyer, we must pass a 3-day exam called the bar exam. You have not passed the bar exam, so you can't cross the bar without permission.
This is defense counsel table.
This is the plaintiff's counsel table. The plaintiff sits closest to the jury because they have the burden of proof. They have to prove their case by preponderance of the evidence. That's not much of a burden. It's a little bit more evidence than we have to have. Nonetheless, they get to sit closest to the jury.
The area between the 2 counsel tables and the bench is called the well. Do not enter the well at all. Big no-no. Tradition dictates that you stay 2 sword lengths from the judge. As stated above, if we are invited up to talk to the judge, it will happen at sidebar.
The judge's private office is behind this door. It is called the judge's chambers. The parties, also known as the litigants, won't be invited into the chambers. Sometimes the judge will invite the lawyers into the chambers.
The judicial assistant, also known as the clerk, sits here. They will be on the other side if the jury box is on this side.
The bailiff sits here. There is no court report in eviction court unless you pay for one. The proceedings are recorded.
Can you identify the bench, the bar, the well, and the witness stand?
Other helpful tips.
Keep calm and watch your tone.
While we learn in the movie Inside Out that all our emotions are useful and must be respected,
In court, you cannot make decisions from a place of fear.
and we must keep these three little monsters under control when we are testifying. Tenants tend to use three tones when telling their story: an angry tone, a whiny tone, or an indignant tone. These tones come from fear and anxiety, but they are not winning tones.
Use your late night FM DJ voice. Deep, soft, slow, and reassuring. And if during an empowerment class I say, watch your tone, then correct your tone. No excuses about how you can't help it.
At the empowerment classes, when talking to opposing counsel and in court, listen to the question.
Answer the question.
Answer only the question. Let's do an exercise. Answer this question in your head. Do you know what color the sky is right now? Ready? Do you have the answer in your head? Most of you probably answered blue. If so, wrong answer. Try it again. Do you know what color the sky is right now? Hint. This is a yes or no question. If the lawyer wants to know what color you think the sky is, they will ask a follow-up question. What color is the sky? And be ready to back up your answer. When did you last see the sky? Isn't it true that there were some clouds in the sky when you last saw it? If it was 5 hours ago, how do you know it's still blue? Couldn't the weather have changed? Most people will answer that the sky is blue even on a cloudy day or in the middle of the night. Think about your answer before answering. Don't be like the empowerment class client of the last minute steps in. The attorneys had been trying to settle all morning. The judge became available. He was a good judge for her. And the attorney had cleared all the other cases for the day. The jury was waived and an attorney stepped in, literally without any preparation except the empowerment classes. But she, the client, had her trial notebook and her exhibit notebook, and the attorney was familiar enough with the facts to step in. The one thing she did not absorb from the empowerment classes was listen to the question, answer the question, answer only the question. She had a long and convoluted and mainly irrelevant answer to every question. Do you know what color the sky is? Well, when I first moved here in 1968, it was always gray. That was because there were fewer protections for our air quality, and cars made more smog, and people were allowed to burn trash in their backyard. Plus, the mountains create this force that keeps the bad air here. Where I grew up, there were beautiful tropical breezes that pushes the bad air out of the city. So many good organizations fought for us to have strong air quality laws. But not in 1968. The sky was always gray in LA in 1968. The bad air quality gave me headache, too much smog from all the cars and trash burning, and the gasoline had lead in it because of weak laws. Now it's blue often. Judge, ma'am, please answer the question.
The Eviction Defense Network has a 98% success rate in resolving eviction cases. While there is no guarantee, our success rate speaks volumes about our experience, our knowledge, and our commitment. Through our empowerment classes, we are teaching people to represent themselves with a 99% success rate, but only if you follow our instructions. Watch the videos, come to the empowerment classes, do what we ask you to do. Invest the time it takes to get the knowledge and the skills to succeed. People often ask, how often do I have to come? You don't have to come at all. You should come as often as you can. You will learn something new every time. You will absorb not only information, but a feeling of confidence. Don't be like our client who was smart and educated and organized and too busy and thought she could cut corners, come sometimes, and be in and out of the classes. In the end, she had not absorbed enough of the winning spirit or enough of the skills because she had not practiced them consistently. After a day of jury selection where we were guiding her by text, she felt like she had to take a deal to move. We guided her through the negotiation via text to a decent deal, but she did give up a below market rate apartment. That probably would not have happened if she had been a better tenant empowerment program student. Join us on Monday and Wednesday at 5:30 p.m. and Saturday at 8:30 a.m.
Our community is a ship in a storm. We are taking on water, and that lawyers are all in the water rescuing others.
We can only give a lawyer to 10% of the people who need lawyers. That means that 9 out of 10 of you need to learn to swim.
Help bailing water by educating yourself. These empowerment classes and webinars will give you the knowledge and skills you need to survive until a lawyer frees up or until you are strong enough to represent yourself.
We are available to you 6 days a week.
Help be efficient at the empowerment class and webinars by watching how to get legal help on the front page of EDN website.
and by reviewing from Zoom to Victory regularly.
To know to rename yourself. Note how to rename yourself.
And have a current, up-to-date PIP ready to post in the chat when asked to do so.
We are fighting for a better tomorrow.
A future where there will be enough lawyers for everyone.
In the meantime, we are rescuing hundreds of tenants that have gone through the process successfully and are willing to help others. We are also recruiting organizers, teachers, the faith community, labor unions, and the staff of social and service organizations.
Remember that the EDN office is overloaded. Use your main email stream. Reply all. But if we don't get back to you, you need to come to an empowerment class or a webinar.
If you are confused or need emotional or moral support, please go to a tenant support group meeting.
You are here in the video series.
Be a winner. Attend the empowerment classes and webinars regularly. Together, we can all be winners.
Arrive on time.
Mute and rename yourself as soon as you're in or you join.
Watch our videos over and over and take notes. It takes multiple times to absorb all the information.
Come prepared with your current PIP ready to put it in the chat when asked.
Come prepared with your trial notebook and exhibit notebook. The trial notebook has all of your court papers. Your exhibit notebook has your proof. Watch the videos on how to put them together.
Memorize your case number, opponent's name, opposing counsel's name, and the department number. In the empowerment class, we do not want to waste time listening to you shuffle through papers to find this information.
Listen carefully when we are answering questions from other tenants. You never know when another tenant will ask what you are going to ask. And if they do, please don't ask the same question. You also never know when another tenant will ask something you wish you had thought to ask.
Be respectful of the attorneys, staff, volunteers, and other tenants.
Practice your late night FM DJ voice.
And memorize the shipping a storm speech. Because together we
Hold
can
on.
all.
You missed a slide.
And again.
123.
123. Oh my goodness. Practice your poker face.
And memorize the ship in a storm speech. Yes, memorize it, because together we can all be winners.
We look forward to meeting you at the empowerment classes and webinars. And remember,
When we fight,
we
win.
Okay?
Yeah, okay.
Whoever wins the next point will be our new champion. No point. 5, 8. Hey! Finish him, Johnny! It's over, Johnny! Yeah, you did it! Marshall, you okay? Can you go on? Get him a body bag! Yeah! contact with the knee. Finish him!
If you have time, please watch the bonus slides and the difference between judges, commissioners, judges pro tem. You won't likely need this information at the first appearance, but it would be good to get a head start.
Judges, commissioners, and judge pro tems, also known as bench officers. The first appearance is about negotiating, but just in case, you should know the difference between judges, commissioners, and pro tems.
Judges usually look like this,
Or this,
but they can also look like this.
or this. On the left, Chief Justice of the California Supreme Court, a Republican appointee, somewhat reformed, was the brain behind Rule 1, which was in place from April 7th through October 5th, 2020, and lowered the eviction filing rate in LA County by 90%. On the right, U.S. Supreme Court Justice Sonia Sotomayor.
So if judges can look like this, what do commissioners look like?
Yup, they look like judges. But they are not judges. They are appointed by County Board of Supervisors, usually to address staff shortages. You have a right to a judge. A commissioner can only hear your case if you give them written permission to hear your case. That written permission is called a stipulation to the commissioner. What does a judge pro tem look like?
Yep, they look like judges. A judge pro tem is a lawyer acting as a judge for one day. Never agree to a judge pro tem without getting our approval. If you can't reach us, say no, thank you.
In the courts in which EDN practices, we have 4 commissioners. We recommend you sign the stipulation to keep Boxer in Department 97 downtown and Gridiron Winston in West Covina. We recommend you refuse to stipulate to Dodson in Pasadena and Acevedo in Compton.
As stated above, you have a right to a judge, and to give up that right, they need your signature. Sign this stipulation for Boxer in 97 and Gridiron Winston in West Covina. Refuse to sign it for Dodson in Pasadena and Acevedo in Compton. If you refuse to sign, you will be assigned a judge. You may have to come back to this court a few times before that actually happens.
Some courts try to keep the trials in the original courtroom that you were assigned per the notice of case assignment in your summons and complaint packet. That is true for all 4 downtown LA departments in West Covina. You aren't going to agree to have Commissioner Acevedo, Compton, or Commissioner Dodson in Pasadena hear your case, so for sure you will be sent out to another court for trial. That new court can be anywhere in the county. That new court can be anywhere in the county. If you are disabled and can't travel, make a reasonable accommodation request now so that your case stays in your home court or a nearby court. We can help you fill out that at an empowerment class if you ask. When you are assigned a new judge, ask for the correct spelling of the judge's name, the court, the department, and 15 minutes to decide. Text, I was just assigned to judge, say the judge's name. say the department number, say the court, and when you are to report. Spell the name correctly. Example, I was just assigned to Judge Caddo in Department I in Van Nuys Court to report tomorrow at 9 a.m. We will text back keep or 170.6. Have the 170.6 form already filled out, 3 copies, except for the name of the judge and the date and your signature. If we text 170.6, fill in the name of the judge, date, and sign it, and give 1 to opposing counsel and 2 to the clerk. The clerk should stamp and give you 1 back, but may not be willing to stamp it. If that happens, take it back unstamped.
As always, fill in your name, address, and phone number.
State that you are a defendant in pro per, meaning you're representing yourself.
Fill in the address of your court.
Fill in the plaintiff's name as it appears in the complaint.
Fill in the defendants as they appear in the court in the complaint. I'll say it again. Fill in the defendants as they appear in the complaint.
Fill in your case number. Leave the information about judicial officer blank because you don't know it yet.
Fill in your name in 2 places below.
Check that you are a defendant.
Print 3. Put them in the front packet of your trial notebook. You will fill in the judge, the judicial officer information, and the date by hand on each of the 3 copies once you are ready to use the form. When they assign you a second bench officer, text as the name, department, and court.
Congratulations. You are now ready for your first court appearance and got a head start on the next video.